all of you are doing well. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be discussing on the topic Independence of Judiciary in a Democracy. Let's start with an introduction. An independent judiciary is very essential for the functioning of an effective democratic system. An independent and impartial judiciary is required for the protection of the basic rights of the individuals and to dispense justice without any political fear or favor. The judiciary is the protector of the constitution, and as such, it may have to strike down executive, administrative and legislative acts of the centre and the states. For rule of law to prevail, judicial independence is of prime necessity. The independence of judiciary is normally assured through the constitution, but it may also be assured through legislations, conventions and other suitable norms and practices. The independence of judiciary depends on the totality of a favourable environment created and also backed by all state organs including the judiciary and the public opinion. Independence of judiciary forms the basic structure of the constitution. Therefore, it is necessary to protect this principle against the ever-changing social, political and economic conditions. It cannot be left unguarded or unprotected. In India, the question of independence of judiciary has been a subject of debates and discussions over a last decade. It becomes more relevant when the judiciary tries to exercise the control over the executive and legislative and declare their acts or orders against the provisions of the constitution. In India, the theory of separation of powers is being followed. All the three organs of the government have their own spheres and functions. One organ of the government does not interfere with the functioning of the other organs of the government. Independence of judiciary implies that the judiciary functions in an independent manner without any influence from the legislature or executive. This is necessary for the smooth and effective governance of a country. Judiciary is given power so that they can also keep a check on the use of arbitrary exercise of the power by the legislature or executive. There must be checks and balances on other organs of the government. The principal role of the judiciary is to protect the rule of law and to ensure supremacy of law. It safeguards the rights of the individuals, settles disputes in accordance with the law, and also ensures that democracy does not give away to individual or group dictatorship. In order to be able to do all this, it is necessary that judiciary is independent of any sort of political pressure. Now let's talk upon the historical background of independence judiciary. The first political philosopher who propounded the idea of an independent judiciary was Montesquieu, the famous French philosopher. He believed in the theory of separation of powers of the three branches of the government: legislature, executive and judiciary. The American Constitution is strictly based on the theory of separation of powers. They also propagated the idea that independent and powerful judiciary is essential for the effective governance of the country. They are convinced that if any one fetters are placed on the independence of judiciary, the rights and liberties of the people might be endangered. In UK, however, the parliament is supreme. The judiciary there has not been separated from the legislature. In England, the separation of powers is not followed as the parliament has the exclusive power to control the affairs of the country. Though in UK, the judiciary has not been made independent or supreme, yet its judges have been giving decisions without fear or favour on any matters coming up before them. They have been independent and impartial in their judgments. The UK does not have a written constitution, but still its people enjoy no less liberty than the Americans. In UK, no major clash between parliament and judiciary has occurred so far. The concept of independence of judiciary took time to grow in England. Before 1701, judges held their office during the pleasure of crown, and like any other crown servant, they could be dismissed by the king at its will. The judges were thus subservient to the executive. The judicial independence was secured by the Act of Settlement 1701, which declared the judicial tenure to be good during the behaviours, and that upon the addresses of both the Houses of Parliament it would be lawful to remove a judge. This position regarding security of judicial tenure is now secured by the statutes. The judiciary in the UK is not competent to declare a law passed by their respective legislatures as unconstitutional. But in USA and India, in both the countries, the judiciary has been vested with the power of judicial review. They can hold a law passed by the legislature as unconstitutional and strike it down. In India, the Supreme Court strikes down a law only if it violates the basic structure of the Constitution. Indian Constitution does not strictly follow the doctrine of separation of powers, but it does provide for the distribution of power to ensure that one organ of the government does not trench on the constitutional powers of other organs. The concept of distribution of power assumes the existence of judicial system free from external as well as internal pressures. Under our Constitution, the judiciary has been assigned the task of safeguarding the fundamental rights of our citizens and upholding the rule of law. Perhaps the most important power of the Supreme Court is the power of judicial review. Judicial review means the power of Supreme Court or the High Courts to examine the constitutionality of any law if the court arrives at the conclusion that the law is inconsistent with the provisions of the Constitution, and such a law can be declared as unconstitutional and inapplicable. The term judicial review is nowhere mentioned in the Constitution. However, the fact that India has a written constitution and that the Supreme Court can strike down a law that goes against fundamental rights implicitly gives the Supreme Court the power of judicial review. Now, let us talk over the role of independent judiciary in democracy. India is the largest democracy in the world, and any healthy democracy cannot thrive without independent judiciary. As a safeguard against potential violations of rule of law, an independent judiciary provides the guarantee that justice is carried out impartially. As Dr. B.B. Chaudhary writes, justice, which is the soul of the state, must be administered without fear or favor. Various provisions have been included in the Indian Constitution to ensure independent judiciary. This includes appointment of judges, salaries and allowances, procedures on the removal, and even the power to penalize in the case of violation of the law. The importance of an independent judiciary is highlighted for various reasons. Firstly, the judiciary serves as the first line of defense against any excessive or unauthorized powers of the executive or legislative branch, providing a system of checks and balances. Furthermore, the judiciary examines and, if needed, invalidates any law that violates the Indian Constitution by declaring it null and void. This further prevents any centralization of power. An impartial judicial system is essential for defending the rights of minorities and other marginalized groups in a multicultural and diversified nation like India. In addition, a strong independent judiciary is essential to maintaining rule of law. It ensures that everyone is governed by the same set of laws irrespective of their position or power. Judicial activism empowers the judiciary to proactively protect the citizens' rights, by going beyond the rigid interpretation of laws or the constitution. It bridges the legislative gaps, ensuring the safeguarding of fundamental rights when the legislature falls short. It adapts the legal principles to evolving societal needs and acts as a check on executive authority, preventing overreach. This activism defends democracy, minorities, and marginalized groups while promoting equality, social justice, and good governance. Public interest litigation in India empowers the citizens to address the issues affecting the public at large, not just individually. The judiciary has actively used this public interest litigations to champion the environmental protection, sustainable development, and wildlife preservation. It has been instrumental in upholding the individual liberties, including right to privacy, freedom of speech, and combating the discrimination. Many landmark judgments have also advanced education, women's rights, decriminalized homosexuality, leading to significant societal change. Now let's have some views on the constitutional provisions. Though in India, there is no express provision in the constitution, but the independence of judiciary is embedded in the letters of various provisions of the constitution. Independence of judiciary and rule of law are the basic features of the constitution and cannot be abrogated even by the constitutional amendment as observed by the Honorable Supreme Court in the S.P. Gupta versus Union of India case of 1982. The Constitution of India is the fundamental law of land, from which all other laws derive their authority and with which they must conform. All powers of the state and its different organs have their source in it and must be exercised subject to the conditions and limitations laid on it. The Constitution provides for the parliamentary form of government, which lacks strict separation between the executive and legislature, but also maintains a clear separation between them and judiciary. Article 50 of the Indian Constitution specifically directs the state to separate the executive from judiciary in the public services of the state. The Supreme Court has used this provision in support of separation between the judiciary and the other two branches of the state at all the levels from the lowest court to the Supreme Court. The independence of judiciary in India is secured in the matter of appointment of judges and their security of tenure. The Constitution of India adopts diverse devices to ensure the independence of judiciary in keeping both the doctrines of constitutional as well as parliamentary sovereignty. The process of appointment of judges also ensures the independence of judiciary in India. Article 124 and Article 217 of the Constitution of India governs the appointment of judges. It provides that judges of the Supreme Court and High Courts are appointed by the President. The Constitution of India has made it obligatory on the President to make the appointments in consultation with the highest judicial authorities. He acts on the advice of the Cabinet. It also provides that the President of India appoints the judges of the High Court and Supreme Court after consulting the Chief Justice of India and the other judges. This entire process evolved into collegium system in India, where the Supreme Court's 4 senior judges and the Chief Justice recommended judge transfers and appointments. 3 judges case developed this system in 3 stages. These 3 cases occurred between 1982 and 1998 and changed the entire process of appointing the judges in India. In the first case, that is S.P. Gupta versus Union of India of the year 1982, the court stated that the President of India can reject Chief Justice's recommendation for cogent reasons. This decision shifted the balance of power in judicial appointments and transfers. In selecting or transferring the judges, the President of India may choose not to consult the Chief Justice of India and other judges, creating an enormous power imbalance between the judiciary and executive. In the second judge's case, that is Supreme Court Advocates on Record Association versus Union of India of the year 1993, the court held that in the matter of appointment of the judges of Supreme Court and High Courts, the Chief Justice of India should have absolute primacy. This case was later known as second judge's case. After that, in the reference presidential reference of 1999, also known as third judge's case, the court laid down certain guidelines while appointing the judges. It was laid down that the consultation process to be adopted by the Chief Justice of India requires consultation of the plurality of the judges. The sole individual opinion of Chief Justice does not constitute the consultation. In the matters of appointment of Supreme Court judge, the Chief Justice of India should consult a collegium of 4 senior most judges of the Supreme Court, and in the appointment of the judge of the High Court, the collegium should consist of Chief Justice of India and 2 senior most judges. In 2014, by 99th Constitutional Amendment, Article 124 was amended to include the appointment of the judges by the President on the recommendation of National Judicial Appointments Commission. But in the Supreme Court Advocates on Record Association versus Union of India, the case of 2016, the Supreme Court declared 99th Constitutional Amendment void and held that the NJAC would affect the independence of judiciary. The Constitution provides for security of tenure of judges. The judges of the Supreme Court and the High Courts serve during good behavior and not during the pleasure of President, as is the case with the other high government officials. They cannot be arbitrarily removed by the President. They may be removed from office only through the process of impeachment. A judge can be removed on the ground of proved misbehavior or incapacity on a report by both the House of the Parliament supported by a special majority. The salaries and allowances of the judges are charged upon the Consolidated Fund of India. Further, the salaries and allowances of the judges of Supreme Court and High Courts cannot be reduced during their tenure except during a financial emergency under Article 360 of the Constitution. Moreover, the conduct of the judges cannot be discussed by the executive or legislature except in the case of their removal. The retirement age is 65 years for the Supreme Court judges and 62 years for the High Court judges. Such a long tenure enables the judges to function impartially and independently. Article 220 of the Indian Constitution states that no person who has held office as a permanent judge of a high court shall plead or act in any court or before any authority in India except the Supreme Court or the other high courts. These all provisions secure independence of judiciary. Now, what are the challenges that goes with the judicial independence in India? An independent judiciary cannot be taken for granted. It is important to keep in check that the judiciary is not politicized and is free from political influences as much as possible. Otherwise, judicial independence will be at stake. The basic challenges faced by the judiciary are as discussed now. Possibility of biasness. It is expected that the judges should be completely impartial and free from biases while declaring any verdict. The maxim nemo judex in causa sua originated from this idea. It means no one should be the judge in their own case. Next is judicial corruption. Judicial corruption is the exertion of inappropriate influences and situations which affect the impartiality and neutrality of the judicial system. An increase in the judicial corruption leads the general public to lose their trust in the judiciary and ultimately weakens public morale. Influence of political parties. Political influences on the judiciary are a matter of grave concern. The political parties often try to malign and disparage the Indian judiciary for personal and political interests. The members of any political party often interfere to stop the working of the judiciary if the interest is not satisfied. Security issues while discharging the judicial duties. The judges are also human beings, and naturally they are concerned with the safety and security of the families. It is not uncommon for a judge to receive threats for the honest discharge of judicial duties. Life-threatening situations faced by individual judges for mere discharging of judicial duties are not uncommon. Interference of other two organs. Even though the doctrine of separation of powers is followed in India, the other two organs of the government often try to encroach on and limit the judicial powers. Alternatively, the judiciary also tries its best to keep the executive and legislature in check. However, the functional overlap of the organs may take place sometimes, which hampers the impartial working of the judiciary. Lack of transparency in the appointment of judges. The appointment of a judge is done following the collegium system in India to safeguard the judicial transparency. However, there are many flaws in the collegium system that needs to be rectified. Next is the influence on the judiciary from powerful quarters. The influence exerted by powerful quarters for personal and private gains greatly hampers the working of judiciary, and the examples of offering bribery to the judges are very common. Let's come to the conclusion. The Constitution provides for an independent judiciary. Independence of judiciary is important for the purpose of fair justice. There should be no interference by the legislature or executive in the proceedings of the judiciary, so that it may pass a judgment that seems reasonably fair. As a result of judicial independence, judges are free to carry out their responsibilities without the fear of interference from the executive or legislative branches of government. In the case of any intervention, there may be an element of bias on the part of judges in taking a fair decision. In the event of intervention, the judges may be unable to make an objective decision or may be biased in their decision making. Judges should be appointed in a manner that is fair, and that their dismissal should be extremely difficult. Their terms of office should be so long and should be compensated. Judicial independence is critical to upholding the law and protecting the rights of individuals. People's fundamental rights are protected by the judiciary, which serves as a guardian of the Constitution. The judiciary's independence is critical to its performance in this role. It is difficult to suggest any other way to make the Indian courts more self-reliant and keep them away from the influence of other two organs. Thank you so much everyone for your time and attention. It was a great pleasure explaining you about the concept of judicial independence. We have discussed the entire concept in a short span of time, and I hope that the listeners have enjoyed and understood the topic. Stay safe, stay healthy. God bless you. Take care.